Welcome to our Legal Insight series. I'm Hieu, and today we're delving into a critical aspect of every DUI case, the DUI pretrial process in California. For anyone facing a DUI charge, understanding this process is key. Let's break it down into understandable segments. Understanding your rights at the DUI arraignment. The arraignment is your first date in court. Here, you'll face your charges and discuss bail if it applies. Your charges will be a DUI, and if this is your second or third DUI, especially in California, bail will be discussed. Essentially, bail is a guarantee to the court that you basically have put up a collateral in exchange for not going out and committing another crime. The courts have the authority to take you into custody. However, bail is your way out. Usually, bail on a second DUI is $10,000. If you are on probation, then bail will be $15,000 and then $10,000 for the second DUI, totaling $25,000. If you are facing bail, you do not have to put up a collateral of $25,000 or $10,000 or $15,000. You can use the process of a bail bondsman. On top of that, you have the right to request counsel at this stage as well in your case. Decisions and your freedom. We'll talk about how bail is determined, including factors like societal risk and flight risk, and what to do if you can't afford it, including requesting a Humphrey hearing. In many cases, you can get away without having to post bond. However, there are conditions to you being released. Many of these conditions include attending AA meetings, or what they call self-help. B-Roll, bail decisions and your freedom. We'll talk about how bail is determined, including factors like societal risk and flight risk, and what to do if you can't afford it, including requesting a Humphrey hearing. A Humphrey hearing basically means that you cannot afford to post bail, and this needs to be taken into consideration in whether or not deciding to release you or not. On top of that, because many judges know that, then what they do is put conditions on you instead. In many cases, if this is a second or third DUI, you may be able to get out on your OR with conditions. These conditions include going to AA meetings 2 to 3 times per week, or being out and released on SCRAM monitoring. SCRAM monitoring is basically alcohol monitoring, and this is where you wear a bracelet. The power of pretrial motions and negotiating plea bargains. Here, we'll explore how pretrial motions can potentially dismiss your case and the role of plea bargains in reaching a resolution before trial. It's important to know that not every case goes to trial. In fact, 90 to 95% of the cases do not go there. It's more about making sure that you do damage control and making sure that everything is done right. However, in many cases, not all police officers do their job right, and this is where pretrial motions come in. Not only does this apply to police officers, but they also apply to district attorneys as well. A pretrial motion can be run if an officer did take a shortcut to pull you over. In other words, if he pulled you over on a hunch, or if the machine was broken, or if the district attorney took too long. A lot of these pretrial motions can affect the lay of the land on your DUI case. It can result in evidence being excluded, which does not make it to the jury, which strengthens your bargaining position. Why hiring an attorney who practices DUI matters. We'll discuss why having a knowledgeable attorney is critical, especially when navigating the complexities of bail, release conditions, and trial. When you go to trial on a DUI, your attorney will need to know about pharmacokinetics, or in other words, how blood alcohol level is affected by alcohol in which it moves through your system. There will be certain stages, such as the absorption, plateau, and elimination stage. There will be timelines that goes. Your attorney must be up to date and as much educated as the criminal expert that will be testifying against you. It's important that your attorney knows for the purpose of cross-examining and taking apart their case. On top of that, your attorney will also need to know the complexities of bail and release conditions. This is important for the purpose of keeping you out of jail on a second and third DUI. The judge's role in mediating plea bargains. Understanding how judges may intervene in plea bargain negotiations, balancing factors like defense behavior and victim impact is an important part of the pretrial process. A judge will take into account a victim's impact in making an offer on the case and resolving it. On top of that, balancing factors come into play. If a judge sees that a new DA or baby DA is coming out too hard or trying to bully people around, the judge may come in to balance things out and work both parties for the purpose of resolving a case and coming back to something that's more reasonable. And these are just a few of the ways that a judge may intervene in plea bargains. Other ways that they may involve themselves into plea bargain is moving the case along and making it mandatory for a defendant to show up to court at the next hearing for the purpose of resolving the case or getting some type of negotiations going. When pretrial negotiations lead to trial, if a resolution isn't reached in pretrial, we'll prepare you for what to expect in a DUI trial, from jury selection to potential outcomes. As far as potential outcomes goes, in a DUI trial, there could be a hung verdict, not guilty, or guilty. Then on top of that, as far as what to expect in a DUI trial, you will expect a lot of science, and on top of that, there will be several witnesses. The witnesses will be the police officer, crime lab experts, and also maybe somebody who took the blood as well. On top of that, if this is a breath test, then there'll be a PAS coordinator. So there will be several witnesses. On top of that, you'll also have several juries as well. You'll see at least 12 of them. However, of the 12 juries, they will be picked from a panel of 50 to 60 juries. And there is a long process from beginning of trial to the end of trial, which goes out to about 3 to 5 days. Pre-roll. Accessing legal aid if you can't afford an attorney. For those unable to afford private counsel, we'll guide you through the process of securing a court-appointed attorney. When you show up to court, it's important to let the judge know that you are unable to afford an attorney. When this happens, the court will give you what they call a financial declaration form. This is where you fill out your assets, and the judge will look at it to determine whether or not you qualify for the services of a court-appointed attorney. Eventually, you will have to pay for the court-appointed attorney. However, it will be at a much more lower rate than if you hired private counsel. Your next steps and our commitment to your defense. In closing, we'll reiterate the importance of legal guidance in DUI cases. You will be facing a lot of science, prejudice from the juries, and a tough negotiation from the district attorney's office. If you're facing such a charge, don't hesitate to reach out for the support you need from our office. The pretrial process in California is layered and complex. It requires careful navigation, which is where we, the Law Office of Hieu, step in. Contact us for tailored legal support and representation. Thank you for watching.